Okay, we turn now from the post-Brexit law, which, as Maya says, has been written down, to the post-Brexit policy, which has not. Exercising a lot of people in London is what the UK's sanctions policy is going to look like after Brexit. Will we need to continue in close alignment with with others, and if so, with whom, and on what terms? Or is it feasible in any respect to go alone into some of these issues? Might there even be advantages in doing so? Well, we'll come to that. But we have an international panel here, and I want to take advantage of that. So before we turn to the UK, we're going to look at the consequences of Brexit for others, the United States, the UN, and first of all, the EU. And from the other side of the tunnel, as Miriam put it, we have Erica Moret from the Center for Global Governance in Geneva. We have Manuel Lafont Rapnouil from the European Council on Foreign Relations. And if one of them perhaps would like to pick up my first question, perhaps Erica, we hear a great deal in this country about how the UK plays a central role in EU sanctions, from sharing intelligence to the design and the implementation of sanctions, to securing consensus among member states, and to pressing for legal protections. The British view is that Britain is pretty much, if not running the show, at least absolutely central to the show. So could I just ask from the other side of the tunnel how you see the current impact of the UK on the formulation of EU sanctions, and what do you think will happen? What will change in the EU when we leave? And just before I stop speaking, I'd like to read a question that we had from Neil Wiley at Deutsche Bank, which I think puts one possibility. He says, given that the UK is a driving force for the current EU sanctions regime, how will we deal with the EU diverging from and reducing the current sanctions programs? For example, there are already growing calls for cessation of EU sanctions against Russia, and without the UK in the EU, this is more likely to happen.
Thank you. Well, just to begin from a policy perspective, I'd like to make a couple of points, if I may. As everyone here, I'm sure, will know already, EU sanctions have become increasingly important to the EU, but also the UK in the past few decades since the end of the Cold War. They have become increasingly important in recent years, in particular because of the lack of consensus that has been encountered at the UN Security Council. And in that situation, then autonomous EU sanctions have assumed a more important role for the EU's foreign and security policy. And I also note Miriam Gonzalez's point that they will become increasingly important for the EU's trade policy. They have been agreed upon with increasing speed and unity in recent years, and we need to look no further than the cases of Russia and Iran and a number of others, Libya, for example, where we see that. And they're also marked by an increase in sophistication. They've become more innovative, and they have expanded to cover a number of new fields. We don't only see sanctions being used now for the more traditional areas of human rights, democracy, the respect of the rule of law, nuclear non-proliferation. We've seen them expanded in recent years to cover things like respect for Ukraine's national integrity and sovereignty, and there's plans for their potential use in areas such as cybersecurity and other areas.
Okay, accepting all that, what's going to happen after Brexit?
Okay.
Is any of that going to go into reverse, or is this story of success just going to sail on unimpeded?
Well, yes. So just having highlighted, probably in too much length, the importance for the two sides, I think that the person who raised the question before, it's a very important one, that the UK's political clout has been important in terms of maintaining this consensus, and we may see areas where this will be challenged in the future. We only have to see recent elections in Italy, where there's been the calling of sanctions to be lifted. We also are likely to see shifts in areas such as the UK's role as a channel with the US. The provision of expertise to the EU will be, I think, an important one in terms of the seconded national experts and the size and expertise held in the UK's sanctions units and elsewhere. What we need to remember for the UK, though, is that it's very important, this working closely with the EU in terms of when we look at the impact and efficacy of sanctions more widely, the chances of success are increased when we closely combine other foreign policy tools such as mediation, trade, diplomacy, and so on. So working with the EU is a very important aspect in this sense.
Yes, okay, thank you. And we will come back, and I'll particularly come back to you, Manuel, but you mentioned expertise, and I just want to go quickly, if I may, to Sir John Sawers, who you'll know is the former chief of MI6, among many other jobs. He knows a certain amount about intelligence, one might think, and we are said to be great contributors of intelligence to the EU. And I'd just like to ask him, before I come back to Manuel, how important is UK intelligence to EU sanctions? Where and how is it particularly crucial? And are there any circumstances in which you can see the UK withholding intelligence after Brexit that they currently provide?
Well, you've got, David, straight on to the question of listings and the details of the implementation of sanctions regimes. I mean, the prior question you were asking, will the UK's departure from the EU reduce the salience and the force of EU sanctions? The answer is almost certainly yes. And the UK has very rarely been in a position of arguing for softer sanctions than other EU member states. It's usually at the harder end of the spectrum. And as Erica says, there will be growing resistance as the sort of liberal international order comes under greater and greater pressure and begins to crumble, and a more nationalist set of policies become the norm in the main Western countries, then I think the application of sanctions regime, we might see it's past a peak. It might start to decline. Now, but once you've got those sanctions regimes, this is where intelligence really comes into play. Because although the Foreign Office lawyer on the last panelist, Neki, was saying that we try and use overt sources to identify who the individuals are and the entities are that should be listed, actually the original information about them almost invariably comes from intelligence. So take the Iran nuclear sanctions, for example. Knowing which entities in Iran are front companies for programs which are barred by the UN Security Council, enrichment or missile developments or whatever it is, that always comes from intelligence. And then you try and reverse engineer it and find some overt information that will help you then present it in court. So, and the combination of having strong intelligence services in the UK and an enthusiasm for the sanctions regime from the policy side has often meant that British intelligence has been to the fore in producing the information that justifies the listings in the first place and can underpin that in UK, in the Council of Ministers in Brussels. And it's helped, of course, to have the transatlantic links as well and the Five Eyes intelligence partnership, which provides a wider pool of intelligence that would be available to EU member states. And would we ever withhold it? Well, you could conceive. I mean, this whole security relations of Brexit is becoming quite aggravated. I mean, most professionals would say, let's keep the security and defence stuff on one side. Let's maintain as much as we can for the good order and the good defence and good security of Europe. But the EU is playing a difficult game on Galileo. Barnier was saying the other day, there's no way the UK could be part of the European arrest warrant. One by one, those provisions that we've helped design, those programs that we've supported, which are important for UK security, are being undercut by the EU position on the terms of Brexit. Now, if that gets to a stage of being not just an irritant, but undercutting UK defence and security, then there may be an unwillingness to share information, especially if there are sanctions which the UK is fairly sort of, uninterested in, or may show breaches by UK banks or UK companies involved in EU sanctions. I'm just suggesting that. I think it's unlikely, but it's not being helped by the should we say, the inability of the British government to move forward the Brexit negotiations itself, and the very hard line that's coming from the EU 27 on the other side of the negotiation table.
We heard a speech yesterday from the director of GCHQ on the subject of intelligence sharing in Europe. Should we read any sort of a threat into that?
No, I think that was the orthodox statement, frankly, that the professionals would like the intelligence sharing to continue as it is at the moment. And you know, when I was chief of MI6, basically I took the decisions on what intelligence to share with other countries and other services, because it was done on the capacity to protect that intelligence. Now, occasionally I would tell the Foreign Secretary what I was planning to do, and if he wanted to object, he could do so. But it wasn't a question of of ministers deciding what to share. That was a professional decision of the heads of the agencies.
Manuel, you've been very patient, and we need to get back across the Atlantic, but can you, in just 2 or 3 minutes, tell us what you think the effect of Brexit is going to be on the EU in the sanctions field?
So I am the French voice who can confirm that even the French recognize that the UK has a key role and is a driving force. And intelligence, indeed, is sort of the most visible element of that, but it's not the only one, certainly. So the interest of both sides, the EU and the UK, is that there is cooperation, as was said, and that we find ways to organize this cooperation beforehand, not when we need to cooperate. There will be other places where there will be cooperation. There is already a lot of bilateral cooperation, for instance, in the UN. There's cooperation on sanctions in the G7 format. So all these should be quite conducive to keeping a fair degree of cooperation. But obviously what you want is not just a fair degree. But on the other side, the EU will want the order of the day in Brussels and in key capitals is strategic autonomy. So you don't want to depend on, for instance, British intelligence to be able to pursue your sanctions policy. And so one thing that will happen is also that other member states, the 27, or some of them, will actually step up in terms of their own capabilities, certainly in terms of intelligence, and certainly in terms of what was said earlier about the role of open source information, because that one is key for listing. You can have the intelligence that makes you understand why you need the sanctions and what you are going to target at, but to substantiate the listing, you do need open source intelligence, and that is one area where the UK is really playing a kind of a lion's share role in the EU. There will be coordination. The key question is coordination and alignment are not the same thing. These are words that have been used. I don't expect alignment, even with Norway or Switzerland, and Norway or Switzerland don't really have the same kind of active and global foreign policy that the UK has. Even with these two countries, there is no strict alignment. But obviously, the closest you are to alignment, the more advantages you have in that cooperation. I must say, I recognize that there is, in theory, a risk of a drift. I'm not sure the drift will happen, and clearly this is not what we've been starting with. The idea that the UK is transferring EU sanctions in domestic law is one good baseline for that. And also because the alternative to close cooperation and coordination with the EU is basically alignment on the US. And for the UK, well, you may want to decide that alignment on one power is better than alignment on the other. But I think the problem is with alignment, and clearly the discussion and the coordination and the influence with Washington doesn't look so good in terms of what you can expect from that these days. But more importantly than that, the economic interest, the foreign policy interest, and also the philosophy of sanctions that we have in Europe in common between the UK and the rest of the EU is much stronger, and there's a stark contrast with the kind of much more aggressive, less focus on the multilateral part of more punitive also way that the US have been doing sanctions, increasingly with the current administration, but already before that. Just one last point on priorities. That is going to be an important thing, and obviously there are specific situations for which the UK cares, or specific UK interests, that will be less well reflected in the discussions in Brussels if the UK is not part of those discussions. But sanctions policy basically is crisis-driven. And so if it's crisis-driven, it's hard to expect a major crisis that impacts key UK interests, but does not impact any EU interest. You will still have someone in the EU who will be impacted, be interested, be concerned by a situation that is key for the UK. What could happen is more in the way we do sanctions. And I know that the reputation of the UK is to be harder, and it's partly true. I must say that sometimes it's not the case, and your question was actually the other way around. Will the UK use the flexibility to protect its economic interest? And you can look at it from both sides. Already, Russia is one example that is often given of an issue where the UK was much harsher than some other Europeans. But I remember this article in the British press where there was this pic taken from someone going to 10 Downing Street with his paper outside of the dossier. Never do that. And it was written in plain that the idea was that nothing of financial sanction that would impact the city. So you're always harsher depending on your interest, and that is going to be the tricky part in the discussion, I think.
Okay, well, thank you very much, and that's a good preview also for what we're going to say later about UK policy. But I'd like to go over to America now. We're very lucky to have with us Harold Koh, who I first got to know when he was legal advisor to the US State Department in the Obama administration. And my question for you, Harold, is how did the US, how does the US look at the UK in sanctions terms? Are we a way of achieving alignment, of promoting US foreign policy goals within the EU? And if so, how is that going to change after Brexit? Are other bridges into Europe going to be found? Or in the political situation we're in at the moment, is alignment a lost cause anyway?
Well, David, you describe it as if the United States is run by a single organizing intelligence. When Americans hear sanctions, and this is a very important point, it's like Americans and Europeans and Brits talking about football. You think, or the Europeans think, it's this beautiful coordinated game. Americans think it's about crunching people and giving them concussions and war by other means. And what you heard from Miriam Gonzalez, which I think is exactly right, is once you get into the unilateral sanctions game, the question is, which way do you lean? What kind of football are you going to play? And I think what we're going to see, David, is 5 kinds of struggle. First, alliance struggle. You know, with leaving the Iran nuclear deal, Trump is saying to the Europeans, choose between doing business in America or choose with Iran. And he wants to crunch them and make it difficult. He said, we want to have the strongest sanctions in history. And so we've seen this movie before, the Soviet pipeline controversy, Helms-Burton, and the rubber will hit the road, as they say, with extraterritorial sanctions. Second, Congress and the executive and Parliament versus the executive, because in America, Congress supposedly has the power over foreign commerce, cares a lot more about things like human rights. You see that Donald Trump doesn't care much about human rights. Magnitsky is a clear example of this. A third kind of struggle will be between ministers and their bureaucracies. You guys made yes ministers, so you know all about that. A fourth kind of struggle will be between agencies. In the United States, the State Department will want to have good relations with both the UK and the EU for other kinds of multilateral national security purposes, where John Bolton, who's the national security advisor, isn't going to have this kind of nuanced approach. And finally, there will be legal struggle, namely litigation. This SAMLA, or this new statute you have one of the best public law bars in the world. I'm looking at many of you. I happen not to be associated with the Brick Court Chambers, but I hold it in high regard. And there are a lot of words in this statute that people will and can litigate, and they will. And not only on the licensing issues, but also on the terminology issues. So I think, you know, strap on your seatbelts. This is not going to be a polite exercise. We're going to be watching a lot of turmoil in the months ahead.
David said in the previous panel that the structure of the new British law was very familiar to a US reader. And certainly when I was reviewing the terrorism laws, and in particular the Terrorism Asset Freezing Act, I had the very strong sense from the Treasury that they were keen to align so far as possible with what the US Treasury was doing. Do you see a United Kingdom free of the shackles of the European Union, able to enter into a closer sanctions cooperation with the United States? Or is that just one of these Brexit myths that seem to be about at the moment?
Well, you know, the structure may be the same, but the question is, what is the zeal with which these laws are enforced? In 1982, I worked in the Justice Department under the Reagan administration, and that was when British companies like John Brown were being caught between what they called Reagan and a hard place. And you're going to have the exact same issue between being caught between Trump and a hard place. I remember at the time I asked the Assistant Attorney General for Antitrust Enforcement, how do you feel about extraterritorial enforcement of sanctions and how it affects European companies? And he said, if we enforce it, it's not extraterritorial. And, you know, so I think we're going to see that, pushing the nexus requirements to the limit. And, you know, the White House will be saying, we want the strongest sanctions in history. And that means taking it to the limit in terms of what they think law will permit. And then you'll have other parts of the government and other parts of the world saying it's too much. And there's going to be a lot of litigation.
If I could just add to that, David, I think historically the UK has been closer to the United States than it has been than other European states. But the point about sanctions regimes are that they try to achieve a policy goal at an economic cost. And the willingness of the UK to go along with the sorts of measures that the US sometimes introduce, where very often the US has got no trade interests at all. Iran was a good case in point. Iran had the most far-reaching, the United States had the most far-reaching sanctions against Iran, but it cost America nothing because there was no US-Iranian business in the first place. Whereas in Europe, it's much more nuanced than that. And especially given London's role as a financial center and the increasing salience of financial sanctions, I think there will be some caution anyway about there being a sort of a UK-US or a transatlantic bloc on sanctions as opposed to a continental European bloc. And under the current US administration, very striking that even amidst all the sort of Brexit chaos, whenever there's been a sharp division between the European Union and the United States, whether it's on climate change or Iran policy or on China trade wars, the UK's position has been identical with that of the European Union, and there's been no sense of wanting to drift off into some mid-Atlantic position. So whilst in theory, David, that's possible, and it might be the case under a future style of US administration and UK government, I think all the evidence so far is that the UK's interests and instincts are more in line with Europe than they will be with a transatlantic approach, especially under President Trump.
David, if I could just mention one area, so the US will be more aggressive generally, but on Russia, we're going to have a battle. You know, Trump just said, I think that Russia should be back in the G7. You guys had Salisbury, and you know, that was what finally pulled Trump along to do sanctions. So Magnitsky and human rights in Russia are a huge concern over here. They're a huge concern to our Congress, but obviously less so to our political branch. So this whole issue is going to get worked out, and it could well be that the European Union and the UK are pushing America on Russia sanctions.
Okay. Well, we're going now to Kim Prost. the judge of the International Criminal Court, who was the first ombudsperson for the UN Security Council Al-Qaeda Sanctions Committee. And I'd like to ask him some questions about the UN. The case of Qudsi was mentioned, which several of us in the room had some involvement with, and I think it's fair to say a lot of the pressure towards what I having represented Mr. Qudsi, would call procedural fairness in sanctions cases came from the UK. And that, of course, has an impact not only in the EU, but in the UN as well. So my question for Kim really is, does it make any difference to the UN or to the UN Security Council whether or not the UK is in the EU when it comes to sanctions? Whether you want to talk about the formulation of sanctions policy at UN level, or whether you want to talk about the implementation of sanctions and fair process.
Well, two questions there. So let me start with, does it make a difference to the UN whether the UK is in or out? Yes, I think it does, albeit the big question mark I think we all have is in terms of the development of UN sanction policy is how much of a difference will it make? And it's tied very much to what's being discussed. Will this make a difference in terms of how the UK approaches its policy positions at the UN in terms of sanctions? Will it make them more in favor of the sanction process in certain situations? Will it make them more active, or will it make them more reluctant towards sanctions or the use of sanctions? But the big question mark is we don't really know how much of an influence the membership in the EU has had to date, and so going forward, how it will affect them. I think for me, one of the biggest question mark areas, though, is the fair process question, which has already been touched upon in the legal section, and it's the point I did want to make some comments on. It's really a question of, will the UK, the change, become a force for good or a force for evil? And I think we know some things so far. The legislation, and I think we have to be very clear about what this legislation says, because the policy is very clear. If you are listed by virtue of other than the United Nations obligation, you will have a fair process remedy. If you are listed by the United Nations, you will not under this legislation. And that's not a surprising position to me, although for a bit of different reasons than what Nikki touched on, because that's always been the UK's position, which is the issues of fair process related to UN sanctions must be dealt with at the international level. And that's not in any way an illegitimate or an inappropriate position to take. It's exactly the basis for the UN Ombudsperson being created. The UN must provide the fair process at the international level. I have advocated for that repeatedly, and I told Judge Leonards of the European Court of Justice that directly. So there's nothing inappropriate in that policy. However, it is not a legitimate policy. It is not a credible policy to take in terms of domestic legislation and your access to the courts if there is not a fair process mechanism available at the UN level. So to say that you can't have access to the courts when you know, the courts in the UK, when you know there is not a fair process mechanism available internationally, I say that's an extremely problematic position to take. And what we do see, you can quarrel with whether the Ombudsperson is or isn't a sufficient fair process mechanism. You will not be surprised to hear me say, I think in practice it certainly is. But what no one can dispute is there are 13 other regimes, as Maya mentioned, where there is no fair process available. So the effect of the UK legislation is that the UK is prepared to put in place measures against individuals who will not have a fair process mechanism available to them.
Yeah, but hang on, Kim. I was our ambassador at the UN, sitting on the Security Council when the Qudsi judgment came through. And it caused immense problems, not because Qudsi was listed for unreasonable grounds, but because they're all intelligence-based, and you couldn't share intelligence with the European Court and have that intelligence protected. Now, if there is absolutely no reason why the UK Ombudsman couldn't review any issues relating to designations by the UN, and that would inform the position of the UK government in the UN negotiations. But as Nikki was saying earlier, once the UN's made a decision, you don't actually have a discretion at national level. You have to exercise that discretion at UN level. And the UN is not just some amorphous body. The Security Council is made up of 15 member states, 5 of whom are permanent members of that council, and it's the 5 permanent members who, by and large, decide on the designations and the legality and reasonableness of them. And if there are any reasons for, it's not a court of law, it's not the European Court that does it, it's done by national governments getting together and working together in New York.
But my point, which I was coming to, is that I agree with the policy, I agree with the position. What I expect from the United Kingdom on the basis of this legislation is that they will not just be at the UN a supporter of the Ombudsperson position as they have been, but that they will become, finally, an advocate for advancing that position into the other sanction regimes. They must become the first P5 member to state uncategorically that we must extend the Ombudsperson mechanism into the other regimes if this legislation is going to take the position that it takes, which is leave the matter to be determined at the international level. I agree entirely. I've never agreed with having domestic courts and the whole confidential information issue. I was able to get access, finally, to confidential information. I'm one person. I'm Canadian. How trustworthy can you be? And I had security clearance, and it was a battle for me that Harold was at many of the discussions on that issue. So I am the strongest advocate that the national courts shouldn't be delivering fair process, but you can't have it both ways, is what I would say to the United Kingdom. If you're going to leave it internationally, then you better be the strongest advocate in support of the Ombudsperson, and you better be focusing on pushing this fair process mechanism into the other regimes. And if I may just say, sorry, David's about to cut me off, but my other question is, and I know it's an elephant in the room, but presuming the United Kingdom stays in the European Court of Human Rights, I don't see how this legislation doesn't take them down the same road that Switzerland has been taken down by the ECHR in the El Dalumi case. What distinguishes the UK denying court access from the Swiss denying court access, I don't see the difference. So I think there's also an imperative in terms of what's going to happen in the European Court of Human Rights.
Okay, we got less than 10 minutes to deal with UK policy, but to help us do that, we have Qudsi Rasheed, former pupil at Brickcourt Chambers. Nothing could quite match up to that, but he is head of the sanctions unit at the Foreign Office. Now, Qudsi, we heard a lot in the last session about a law of which it seems that lawyers approve. It's a shiny new law, it has lots of effective features, but I think the question a lot of people will be asking is, it's all very well having a nice-looking law, but is it actually any use in a situation where we have decided to cut ourselves off from the regional bloc whose policies we did so much to inform and to implement. So, what is your answer to this? I mean, does it lie in close alignment with the EU? Does it lie in some excursion across the Atlantic, perilous, although Harold has made that sound? Or is it possible to craft a policy where we are independent while not having to go it alone? I mean, maybe we go with the Americans on Russia, we go with the Europeans on Iran. Now, I appreciate you can't speak for ministers, but do you think these are at least possibilities in the brave new world after Brexit?
So I think those are all really relevant questions, and they're precisely the questions that we are considering across government at the moment. I'll start on the point of alignment, because I personally think that's a slight red herring. And I think the points that were made in previous panels about will the UK align with the EU or will the UK align with the US, the UK will have its own independent national foreign policy. That is part of the whole premise of Brexit, and the idea that the UK will either have to pick one side or the other, I think is not where the government is, and it's not where ministers are. And I think it's an important point to emphasise. I mean, the UK has historically been part of the EU, but is also a P5 member, it's a member of NATO, it has 2% defence spending, it's a significant contributor to international development, it's a member of the G7, it's an international actor in its own right. And so the idea that it's forced to have to pick one side or another is not where this government is coming from. That said, I think everyone agrees, and this government agrees, and all ministers have said this, is sanctions are by their nature best as a multilateral tool to have greatest impact. But that's not really an EU question. I mean, the primary multilateral forum in which sanctions can be applied is the UN, because then you do have global coverage of sanctions. And the EU is one forum in which the UK has been involved in sanctions policy, but you have the UN. In the Iran negotiations, everything was done at the E3 and the E3+3 format with Iran. In Russia, lots was negotiated at the G7 format. So there are various other multilateral fora. So I think there are really three layers in which we need to think about UK policy as it formed. I think the first and foremost question will be the UK designing its own national policy on sanctions based on its perception, the UK's perception, of what's in the UK's national interest and what's in the interest of the UK for international peace and security, because it is ultimately a foreign policy tool. And that is something that ministers will have to decide on a case-by-case basis. It's very hard to say unilaterally this will be sanctions policy. It will depend, as I think Manuel said earlier. It's a crisis tool more often than not. I think the second layer is what will the future UK-EU relationship be on sanctions, and this is part of negotiations that are ongoing with the EU at the moment. But I think I would pick up on Manuel's point. There is a very big difference between alignment and coordination, and I think we're very much in the coordination space on both sides.
Well, I mean, if I could just interrupt you there, Qudsi, I was looking at the Commission's Article 50 task force slides they produced last week, in which they summarised the EU position and the UK position, and of course both of them are very keen on consultation. But what was quite interesting to me was the different spin they put on it. So if you look at the EU slide, consult with the UK to eventually enable UK's convergence, time and content-wise, with EU sanction policy. Whereas if you look at the UK position, this is all about EU-UK equal footing on sanction policy. So my question really for you, bearing in mind all the experience you've had, is this question of equal footing simply a delusion? Is it really the best we can hope for to manage to converge, but on the EU's terms?
No, I mean, I don't think there's any question really about equal footing here on sanctions policy. I've been very clear when I've had discussions with EU counterparts that is the premise. The UK's position on sanctions is sovereignty. The UK will have its own national independent sanctions policy that will be justiciable before UK courts. The EU have been very clear that they want autonomy of decision-making, which is the terms they use in their slides, which is their version of sovereignty, that the 27 EU member states will have to decide for themselves what their EU sanctions policy will be, and that will be justiciable before the EU courts. But where it's in our interest, we will work together. And so obviously from an EU perspective, they will see it as the UK converging with the EU. But from a UK perspective, we might say that the EU might be interested in converging with us. So I think a lot of it is about how it's presented. But I think the premise is very clear that we have two different regimes here. I think on the UK-EU cooperation point, I think that the point that's very clear is just how much the UK has been at the forefront of EU sanctions policy to date. I don't think that's debated either here or across the channel particularly. I think the question is how do we best work together going forward? And that is an open question which we're taking forward, both with the EU institutions, but also I think you can't forget the level of cooperation that we have with EU member states, which will continue. The bilateral cooperation on external security policy, broader than sanctions, is very deep with a whole range of EU member states, and that I think will likely continue. And then I think the third level, which is really important not to forget, is the non-EU aspects of sanctions. So the UN I mentioned, US cooperation, G7 cooperation, other international fora in which sanctions are obviously discussed and negotiated.
Okay, well, we're almost out of time, but before the piano strikes up for the final dance, I'm just going to ask Harold if he wants to come in on this issue.
I think the British courts are going to be a gigantic player starting now. I mean, the Parliament has spoken. You're hearing about the development of the UK government position. But the courts and what they say about such issues as due process, et cetera, will be the shaping factor. Now, one thing my friend and colleague David Mortlock pointed out, that the US government usually wins on sanctions, but one way they win is when they're about to lose, they fold. But the British government and the British courts face usually a more skeptical set of courts. And this will force the American regulators to look at what the British courts are deciding to decide whether they can get away with something. Once Al-Sqaini and Al-Jeddah came out the way they did, that really was a wake-up call. When Qudsi happened, the Americans, regulators, suddenly started talking about Qudsi. And most of them couldn't spell Qudsi, and most of them didn't understand the structure of the European judicial system. So I think that this is going to be a very interactive moment in terms of legal analysis. And this bar and your courts are going to play a huge role.
Qudsi wants a short final word. Before he gets it, I'm going to give a short penultimate word to Erica.
Thank you. And this is really to pick up on Quincy's point in particular. What we're looking at here, of course, is that a situation where there's no precedence for the EU, and I think this partly explains their difficulty in formulating ideas going forward. We really have to remember that all neighbouring EU countries, EFTA countries, allied states such as Japan, Australia, Canada, and so on, are invited to align with US and EU sanctions, but do not typically have any role whatsoever in the influencing the decision making. Some of them perhaps do at certain case-by-case scenarios that we've looked at. So what I think is really important here is to think about how can the UK influence. Is some kind of institutional footing required? Is some kind of forum required whereby the UK can actually influence EU measures, because they're going to be important. And it's not just enough to say that getting heads of state or ministers together to influence EU sanctions. This is not going to happen because EU sanctions are formulated in a very complex way at junior levels often, and it involves toing and froing between many parts of the EU, often very quickly in short time frames. So I think a big question here is how does the relationship look going forward in an institutional manner?
Okay, Qudsi.
Well, I just want to pick up on the fair process and rule of law point, because I know Kimberly made a very passionate case on rule of law at the UN. I think whilst a lot has been said about the UK's role in the EU about pushing for sanctions, I think it's also important to emphasise the UK's role in pushing due process. The UK is at the forefront in the EU of ensuring that listings are robust, that there is proper evidence, that the cases are properly argued before the courts, and so on and so forth. And actually, the UK was one of the countries that was behind the creation of the Ombudsperson in New York, precisely to have greater due process there. So I think from a UK perspective, I think Harold's entirely right that our court will rightly properly scrutinise the role of government and provide guidance and as cases come through the courts about rule of law. I think the question will be for other EU partners, particularly as other colleagues have said, who will step up in the EU to play that role of defending the rule of law amongst
But Qudsi, going back to my old intelligence hat, there is no equivalent in the European courts that I'm aware of closed material proceedings. So how can we provide the underpinning intelligence to a judicial process of challenge in the European courts when it's all based on intelligence?
Yeah, so I think that is a fair point, and I think it's one of the reasons why we as the UK have invested so much resource and capacity into open source work, precisely so that we can defend listings that, as you rightly said, we've identified through intelligence, but we defend through open source material. Someone else in the EU is now going to have to do that, or they're going to have a mechanism by which we can share that open source.
Well, I think we need another conference probably on the adequacy or otherwise of the General Court closed material procedure, and indeed the one that's being contemplated in the European Court of Human Rights. But our time is out. I was, I think, inspired or possibly reassured by what Kim had to say when she was asked what the UK influence would be after Brexit, and she said, well, it depends whether it's a force for good or a force for evil. That implied to me that she thought it might at least be a force, which is more than some people are prepared to admit. I'd like you all to thank our speakers. Some of them have come a very long way. They've done a terrific job.